The Pietermaritzburg High Court has set aside Zuma's private prosecution of state advocate Billy Downer and journalist Karyn Maughan. But the former president has since launched an appeal bid. The former president has accused the state and Downer of leaking to Maughan confidential medical information during the course of this arms deal corruption trial. The private prosecution matter is scheduled to return to court on 1 November. For more on this, we are joined by Phelps, a criminal justice analyst. Kelly, appreciate your time this afternoon. Just give us a summation of where this case is and what former President Jacob Zuma's chances are.
Well, I mean, the case is very far in the sense that, Mr. Zuma has shown himself to be incredibly skilled at exploring every possible open avenue to him as far as the legal process is concerned. And I would suggest for that reason that his chances of reaching a different outcome in this matter are not very good at all. Various courts have now commented on it. The law in this area is pretty settled. And he seems at this point to just be playing for time.
So in your mind, he really doesn't have a chance to go any further than he already has with this case?
Yes, well, I mean, I think one has to look at this case in terms of the broader landscape in which it's occurring. And that is in a landscape in which, as far as his corruption trial is concerned, he has tried multiple different avenues to essentially frustrate the continuation of that trial. So we've seen him go after advocate Billy Downer in numerous different ways through numerous different applications. We've now seen him add journalists like Karyn Maughan to that, speaking about things like leaking private information. I mean, that claim alone, whether it's private or not, when it's formed part of a procedure that's a matter of public record, I think is fairly spurious at the best of times. But the point is, I think it's important not to look at each one of these applications just in its own merit, but also to consider that it forms part of a much broader landscape. And the longer he tries this approach with the courts to essentially frustrate the core corruption trial, I would argue the more the courts are going to lose patience with that and see each individual application for what it really is in terms of this broader picture.
So before we take a look at the implications of what all this means to the courts and certainly them running out of patience, as you suggest, apart from the private prosecution against Downer and Maughan, what other private prosecution attempt has Jacob Zuma made, and who's the target of this prosecution?
I'm not aware of any other private prosecution, but he certainly made a number of claims to have the corruption trial thrown out due to various kinds of behaviors from Billy Downer in the past. Largely his claims have been based on his assertion that his right to a fair trial has been impinged. And he's made various accusations that Billy Downer essentially has gone after him as some sort of individual manhunt, and that actually the case should be viewed in that light rather than on the specific legal allegations that Billy Downer has made in court. Of course, it's important to note as well that Billy Downer is just one person, an individual, but he is appearing in these cases in his role as a senior member of the prosecution unit in South Africa, which is a part of the state. So it's really quite an extraordinary accusation to suggest that Billy Downer is essentially manipulating the machinery of the state due to a beef that he has with an individual accused person. But that is the essence of some of the claims that have been made.
So when we talk about an individual trying the patience of the court system, would Jacob Zuma be one of those people when we take into account that even President Cyril Ramaphosa was dragged into all of this, if you will?
Yes, I mean, I think also, just to be clear what I mean by he's trying the patience of the court system, I'm not suggesting for 1 minute that the judges won't, read the papers before them and apply their minds fairly to the allegations or claims that are being made before them. But the point is these individual claims are being made now in the landscape of a matter that has been going on for an extremely long period of time, that has taken many different twists and turns, and that all ultimately are coming down to the same issue, which is, an attempt to further delay and frustrate if not permanently, the eventuality of the corruption trial. And judges aren't immunized from that. They will have been exposed to the other matters that have come before the courts. They will have been exposed to the story taking the particular shape that it has. And it can't help but start to infuse the manner in which you're reading the papers before you.
So when you take a look at President Jacob Zuma and certainly his law team, and the fact that they're continually going before the courts, making all sorts of suggestions and proposals and arguments, what does it suggest about his law team and the fact that he seems to be losing a number of his applications? Well, I don't know if you're the right person to give judgment on that.
I'm going to tread carefully here, but I will say this. One can say that his lawyers are very skilled at analyzing every single potential legal gap and loophole that might exist. They certainly are acting within the terrain of legal loopholes that exist and have shown themselves to be very skilled at finding those and trying to exploit them. And after all, a lawyer's ethical duty is to act in the best interest of their client, which they appear to have done vigorously in this matter. I will say, however, that I think it's probably time for the courts to take a firmer line with the applications that his lawyers are bringing. One can't really challenge the lawyers for bringing applications in the best interest of their client. That is their ethical duty. But not every application is equal before the law. And up to now, courts have been incredibly cautious, at pains to show that they are giving Mr. Zuma a fair hearing. But that has been established now. He has been given a very fair hearing. And I think it starts to strain incredulity when you are this many years down the line of a single matter, and these seemingly minor applications continually are coming before the court, arguing matters that are unusual arguments that are not very commonly put before courts. I think it's probably time for the courts to pull the reins in a little tighter in terms of just how much leeway these arguments are given.
Now, how would that manifest if the courts decided that they were going to tighten the reins, so to speak? What would that look like when Jacob Zuma and his team go to the courts?
Well, it's difficult to speak about that hypothetically because these things happen in very specific ways. So, for example, when certain applications are made before a court will have a range of options available to them. And within those options, there will be a cautious end of the continuum and a less cautious end of the continuum. Now, if you are operating on the more cautious end, you might grant longer postponements, more postponements. You may say yes to some of the requests for additional information that might not be core information coming from a legal team, because you're really at pains to show that there's not a single possible ground on which someone can argue in any which way that they have been treated unfairly. But perhaps it's time to start operating on the less cautious end of that spectrum and acknowledge that there's a very long track record that has been created now that Mr. Zuma has indeed been treated extremely fairly. In fact, he has been given far more latitude and hearing time than any other accused person that I'm aware of in this country in order to truly explore all of his legal options. And when one recognizes that, it might be better for the courts then to give shorter postponements or fewer postponements, or where, in terms of using a bar of what is reasonable, be more willing to find that there's no reasonable prospects of success on some of the more unusual applications that have come before the courts so far.
So speaking of reasonableness, the Department of Correctional Services has announced that in the next week they'll make a decision on whether Jacob Zuma will indeed return to prison or not. What are the considerations for the department when they look at that case in the next week?
Well, I mean, this is a really interesting matter because to say that this is unusual is an understatement. I'm not aware of another case where it's been found that medical parole has been granted unlawfully while it's already being served, and the department has precipitously actually announced publicly that therefore the sentence has now been finished. Of course, they have to retract that now, but they're really in uncharted terrain, so it's very difficult to predict what the outcome will be with that. They've said they're consulting with lawyers in order to determine what sort of impact the time he's already served on medical parole, which we now know was unlawfully granted, should make in terms of him serving out the rest of his sentence. But because this hasn't really happened before, it's very difficult to say what decision they'll arrive at. On the one end of the spectrum, they may say, well, take the judgment very literally. If medical parole was granted unlawfully, then it shouldn't count at all and he should be returned to prison straight away. He's only served 2 months of a 15-month sentence, so he should continue serving out the rest of his sentence in prison. On the other hand, the court left it open for the department to determine if the time spent on this unlawfully granted medical parole should count towards the determination of what is left on his sentence. And if they do decide that, look, even though it was granted unlawfully, that wasn't his decision, it was someone else's decision, and he has been serving time under conditions in the community, they may then decide to discount that from time that is required to be spent in prison. And as far as how they determine that calculation, how much should it discount his time, well, that remains to be seen entirely. So it's very difficult to tell.
Is house arrest a possibility for former President Jacob Zuma?
Well, so in this matter, I think one has to go back to the original sentence, which was issued by the Constitutional Court, and that was on a finding that he was in contempt of court. And if you look at the sentence he was granted originally, he was granted a sentence of direct imprisonment. So I would say that it is not within the department's purview to convert that into house arrest, because that would essentially be frustrating the sentence of the Constitutional Court. If they want to change the kind of sentence that he's been granted, then one would need to go back to the Constitutional Court and put an application before the court and request them to change that sentence. What could happen is he could go back to prison and immediately apply for parole, for regular parole. And, one option under regular parole is house arrest. And should that parole application be granted, then it might be deemed that he's appropriate for house arrest. But I wouldn't think that it would be very proper for them to do that as a first port of call, because that wouldn't be in line with what the original Constitutional Court sentence was, which was one of direct imprisonment for 15 months.
Well, Kelly, the Court Court has said that Arthur Fraser, who was head of correctional services at one of the commissioners, erred. In fact, they said that he broke the law in releasing former President Jacob Zuma. Is Arthur Fraser now in possibly going to be arrested or persecuted for having broken the law?
It seems unlikely. To be clear, there's a difference between breaking the law and acting unlawfully, and I know that's a typical lawyer speak because it sounds like a very thin difference, but it's a very important difference. The court haven't suggested in their judgment that Arthur Fraser was acting criminally, so breaking the law in that way, but rather that he was acting unlawfully in that he acted with powers that, in fact, the Correctional Services Act, does not confer on him. So in other words, he was saying that he could overrule the decision of the Medical Parole Advisory Board, which had advised that Mr. Zuma was not eligible for medical parole. And Arthur Fraser said, I'm going to overturn that. I disagree with you, and I'm going to issue medical parole. And one of the court's key findings was that that was in fact not a power conferred to him by the Act. So it was unlawful in that he acted ultra vires, not necessarily that it was criminal in its unlawful nature.
Kelly Phelps, Criminal Justice Analyst, appreciate your time this afternoon.